Case number 25-05080 Vibe Credit Union versus Teresa Davis Seals.
All right, appearances for the record, please.
Good morning, Your Honor. Elizabeth Butler, P80956 for Plaintiff Vibe Credit Union.
All right, good morning, Ms. Butler. And ma'am, what is your name?
My name is Teresa Davis Seals.
Okay, and good morning to you as well. Today is the date scheduled for 2 hearings, I see.
Buckle up, guys. Today we're going to set the scene. A small claims courtroom, a debt dispute, and a defendant who opens his hearing with a bombshell admission. She left her evidence at home on purpose. That confession flips the script and immediately raises the stakes. The judge, the plaintiff, and everyone in the room now must decide whether words alone can carry a legal defense without documents to back them up. It sets the tone for everything that follows.
We have a motion for summary disposition that was filed by the plaintiff, and then I'm looking at a letter which indicates that Ms. Davis Seals is requesting a motion to dismiss the case. So we'll figure out which one we would like to address first, but I'm thinking let's go with the defendant's motion first. Ms. Davis Seals, what's your argument?
Okay, Your Honor, I would like to say that Ms. Butler has no case, and the information that she has compiled in her packet that she does have, it basically has come from me, from the mediation that we had of my receipts. She has no information, and she's now wanting this hearing to further get additional information from me to work against me, which is ridiculous. And I only came to this hearing today just to find out more about Ms. Butler and her affiliation with this credit union, why she's even with them, why is she working for this particular situation. I have no dealings with her and her organization or her company, and I see no reason to even be having this whole case situation to begin with. I tried working with that credit union one-on-one myself. It was not necessary for them to take this route, and now they have put her out here not equipped because she doesn't have any information. They didn't give her any, and now she wants to use me to work against me, which is crazy. This is why she wants this meeting today. She wants to hear additional information, and I purposely left my information at home. I have additional information other than this makeshift.
The defendant doubles down, insisting the plaintiff's packet is wrong and that she purposely withheld her receipts. From a third-person vantage, this is a high-risk gamble. Theatrics over evidence. The courtroom expects proof, not proclamations. By declaring she'll bring her own story later, she trades immediate credibility for drama. The judge is primed to demand facts now, not promises. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
Okay. Well, now you've asked me to dismiss the case. And in order to do that, we would have to have a legal basis to do that. And I hear that you're not happy with the fact that she's filed the case. You don't understand who she is. You don't like the fact that she's got information from you that she's using in the case, which, by the way, that's okay. Either side can use information from the other side. As a matter of fact, that's a process that we call discovery. And it is authorized under the Michigan court rules that you can ask each other specific questions about your side of the case or their side of the case, whichever you want. Any factual information, questions can be asked. You can ask for documents. Documents can be provided both ways, from the plaintiff to the defense, if the defense wants to see documents that the plaintiff has, and vice versa. So that part is technically okay. But for you to ask me to dismiss the case, I just can't dismiss the case. I have to have a legal grounds to do that. And I'm not really hearing specific legal grounds, although I am hearing some other things that you're not happy about. So,
Your Honor, can I say something else? I just want to bring out all of the rest of my feelings and information.
The judge pushes hard for legal grounds and proof, laying out that dismissal isn't a matter of feeling, but of legal standards. The defendant's insistence on dismissal without evidence is legally thin. The judge's measured insistence exposes the procedural reality. Courts need law, not frustration. This exchange frames a hearing. Process and proof beat emotion in front of the bench. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
and I'm not even sure if you went, maybe you went to mediation. You did go to mediation. Well, at least it was ordered in July. Let's see if you went. I don't know.
Yes, Your Honor, we did go to
We had
mediation.
mediation.
Okay. So usually after mediation, can somebody tell me the date you went? Because usually that's when we would do a scheduling order.
I think it was August 14th.
Okay. So I don't see a scheduling order back yet. This motion got filed though in August.
Your Honor, may I respond to the defendant's motion, or do you even need me to file?
Yeah, well, I'm gonna let you say what you need to say. I just wanted to make sure she was clear on the fact that some of the things she's complaining about are okay. So go ahead and respond, Ms. Butler.
Thank you, Your Honor. I mean, you said that there needs to be a legal basis for a motion to dismiss, and thank you for explaining that my client's entitled to ask for information from her. We attended the mediation, and I had asked her for copies of checks. I wanted to make sure my client had the right balance, that she was given credit for all of her payments. She kindly provided that, and my client reviewed, and we filed our motion for summary disposition based on the balance, and we included a full accounting with the motion. That's what she had wanted to see, and she was served with a copy of the motion. I'm happy to
Let me interrupt you a minute. I'm looking on my electronic filing and I see the motion itself, but I don't see, let me see if there's a brief. I was looking for the brief and I couldn't find it.
We filed a brief with exhibits and a proof of service and a notice.
Okay, let's see. I do see something that says exhibits, so let me see if that's it. Yes, you're right. Says exhibits, but there's the motion. Okay, there's that. Well, no, there's the exhibits. Okay, let's see if I got a brief with it.
Confusion over mediation and scheduling surfaces, revealing a breakdown in communication. For viewers, this clarifies why paperwork and deadlines matter. Missed orders change strategy. The judge's effort to pin down dates and procedures shows how routine administrative steps can decide a case's fate long before any dramatic testimony appears. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
Yes, Your Honor, this relates to a loan that Ms. Davis Seals took out with my client, the credit union. She seems to be under a misunderstanding that my office owns the debt. We're just the lawyers for Provide Credit Union. They still own the debt. We're not a separate debt buyer in any way. We're just humble attorneys.
Yeah, you're just representing the credit union.
Correct.
Mm-hmm.
Ms. Davis Seals had a loan before this loan that's the basis of the lawsuit. The loan that's the basis of this lawsuit was a debt consolidation loan, where she was given a new loan. So Ms. Davis Seals had made payments on that prior loan, and my understanding is that she's concerned she didn't get credit for those prior payments. I think what she's not understanding is that this was a new loan, and the payments made before don't apply to the new loan. The new loan encompassed all her prior payments and what she'd owed before. After mediation, she kindly provided my office with copies of her receipts. I had my client double check everything to make sure that all her payments were credited. She had admitted that she missed some payments, which is the basis of the default on the loan. Attached to the motion for summary is a full accounting of all her payments and also an affidavit of account from my client confirming the balance. That was the basis for the motion for summary. She doesn't seem to be contesting that she took out the loan, that she owes money. She just was worried about the payments, thus the full accounting affidavit of the balance. I'll also point out she hasn't filed a response to the motion. Maybe if you want to consider her letter a response to the motion, she still has not presented any genuine issues of material fact that would justify a trial, nor has she stated any valid defenses. This motion is under 2.116, C9, and C10. If she doesn't present anything that would contest this balance, there really isn't much more for the court to review based on what we've already.
The plaintiff lays out a tight summary disposition, accounting, affidavit, and a claim that the facts are settled. From the sidelines, this is textbook litigation discipline. Present records, attach exhibits, and shift the burden. It's a classic posture, preparedness versus improvisation. The plaintiff's calm preparation amplifies the defendant's peril and accentuates how documentation converts argument into enforceable evidence. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
Provided. That's why we ask that this court consider denying Ms. Davis-Steele's motion to dismiss and granting this motion for summary disposition. Again, there's really nothing to review further at a trial.
All right, thank you so much. Okay, so Ms. Davis-Seals, I'm going to give you a chance to respond, but the gist of her argument is that, number one, she's just the lawyer for the credit union. She's not trying to collect the debt for any other entity other than the credit union, and that's how she's involved in the case. Number two, she indicated that at the mediation, she got your documents to make sure that you were...
A sharp, biting exchange. Courtroom tone elevates. Quick, pointed remarks underscore that civility and precision matter. For the audience, this is a turning point where tempers and credibility begin to trade places. The defendant's informal language meets the plaintiff's procedural posture, and the judge's reactions hint that sloppy theatrics won't sway a legal ruling. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
No one's disputing the facts.
I'm disputing. Your Honor, let me speak on each one of those issues you just mentioned. Number one, this is a debt collection agency that's working for them. They have bought out this account from this credit union.
There's no evidence of that.
They have. The paperwork that I read. Let me finish talking.
I need you to, I have to be based in reality here. So I need you to show me what documents you have that support the fact that they bought the debt and that they're actually the people collecting it, because the lawsuit is not in the name of the law firm. And it's okay for a debt collection law firm to represent the credit union because the credit union is trying to collect a debt. And they typically do hire debt collection firms to do that. So
Okay, let me finish.
Ma'am, you can't say that to the judge.
Listen,
Okay,
I'm sorry.
Okay,
I'm not there,
okay.
and I'm not going to try to overtalk you.
A contested claim about whether the debt was sold shifts the legal focus to chain of title and standing. Outside observers should note this change. The fight goes from receipts to ownership. If the creditor lacks standing, the case collapses. If they have a chain, the defense faces trouble. This moment reframes liability into a technical, decisive argument that can decide the case without revisiting every disputed payment. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
The whole situation. I took out the loan, and I did that. It was a double loan. I started with one. They merged that first one in with the second one. It became a combined one loan. Out of that one loan, I have paid over $8,000 and plus dollars for that whole loan. It became a consolidated one loan. And they are not accurately giving me the credit for the amount that I have paid.
Okay, ma'am. Well, you're going to have some documentation to show
I have
me.
it. It's at home. Like I said, I didn't bring anything.
Today was the date to bring it. We don't get to trial when there's a motion pending. And in order to actually respond to the motion, you needed to have brought your information today.
It was my understanding this was just a hearing before the trial.
It is a hearing before the trial, and it could end up that you don't get to trial if her position is substantiated.
Emotional testimony. The defendant insists she paid over $8,000 but lacks the documents in court. That's dramatic, but in legal terms, it's a risky bluff. The judge's repeated demand for documentation turns sympathy into skepticism. For viewers, it's a lesson. In court, heart-tugging claims need paper trails or they evaporate under judicial scrutiny. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
We don't get there. This is the date to do that. This is a motion for summary disposition. That means this is the date where the case could be totally dismissed and we don't get to trial based upon their motion. This was the date for you to file a response, like she said, which you did not do, but that's okay. If you had brought some information today, we could have dealt with it orally to some degree. But if you don't have anything, I can't just go on your word that they did something false.
I have it at
Gotta
home.
have document. Ma'am, you were supposed to, I don't know why you would come to a court hearing without the
Because
proper.
I thought this was just a hearing, that we were just supposed to voice. It was another, I thought it was similar to that orientation we had, which, by the way, she started with one sheet of information. Then all of a sudden, after I submit my receipts, she comes with a bogus packet, of which over 99% of this packet is incorrect. And this is why I thought this was just another hearing to voice why it should go, like you said, go any further or not, because none of what she has in this packet is correct. And they
have no evidence to show that none of what she has in
And
the
I'm
packet.
sorry, I made the mistake. And it's at home. I have the information to show it.
The judge explains summary disposition mechanics, how burden shifts, and why oral claims can't replace exhibits. This is a crucial educational beat. From a commentator's perspective, this is the courtroom teaching point. Law is procedural first and evidentiary second. It's where the practicalities of litigation meet the human story on display, and it clarifies why the judge can rule on legal sufficiency without a full trial. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
And had I known that this meeting today was going to involve my not going on to the 25th of September, I would not have made that mistake. And that's where legal defense comes in. And I've been done a grave injustice where ever since this mess here has started regarding the lies regarding what I have paid to this credit union.
Okay, let's hear back from the plaintiff before I resolve this.
Your Honor, the only point I'll bring up is Ms. Davis-Seal said she never missed a payment, she was only late. Being late on a payment does still constitute a default under the loan agreement. She was late on a few payments and made them, but she also, from the transaction history attached to the motion, missed a payment in August of 2023, October of 2023, and a short payment in March of 2024. That's all in the transaction history attached to the motion. Thank you, Your Honor.
Your Honor, may I say something?
No, ma'am. At this point, I gave her an opportunity to respond back to you because she has the burden of proof. Because we can't go back and forth like this all day. So
The defendant recounts being dropped by her prior counsel, a humanizing flash that adds texture. It complicates judgment. Was she abandoned unfairly, or did professional standards guide the lawyer's choice? For viewers, it injects empathy, but doesn't negate the need for proof. It's a poignant interlude that raises doubt about access to justice versus evidentiary rules, while highlighting why representation and timely evidence collection matter. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
The basis of which is that there is no genuine issue of fact that requires a trial. This motion was served upon and filed with the court and served upon the party defendant at least, at least 28 days ago, specifically it looks like it was on the 18th of August. So at this juncture, the defense has had notice of the motion, notice of today's date. She's appeared here today. She could have filed a written response to the motion. She did not do that, but she appeared and made her argument that there's some kind of fraud she thinks that the credit union is perpetrating against her. She's made her argument that she was not fairly credited with a number of payments that were made on her loan, and she brought no proof of anything today. And this is the date of the hearing where the proofs should have been brought, because in a motion for summary disposition, the plaintiff has the burden to bring forth some evidence, and once they do, then the burden shifts back to the defense to bring forth additional evidence to refute or rebut the plaintiff's evidence, and therefore creating a question of fact for trial.
The plaintiff points to transaction history showing mispayments. The record pushes back on the defendant's narrative. This moment is where documents speak louder than statements. For an outside observer, it highlights a central truth. Paper often settles disputes courts can't resolve on gut feelings alone. The balance tips toward the plaintiff as the ledger is foreground and the judge emphasizes documentary weight over argument. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
I just found it. It's in this packet. I thought I just had her information, but my information about what I paid is here on this sheet.
Okay. And quite frankly, let me take a look, because I don't have that. And everybody is required to provide in advance. That's why we give all this time for these motions to be heard, so that everybody can review it and see it, including the court. I've got all the documents I need in my file right here, except for what you got there. And you're asking me to look at something that I can't even look at this point. So I'm going to ask counsel, could you please grab what it is that she's got and tell me if you've looked at it before?
Your Honor, I have not seen this before. It looks like a handwritten ledger.
The defendant suddenly produces a handwritten ledger mid-hearing, a dramatic reveal, but timing matters. Introducing new material at the 11th hour reduces its impact. The judge and counsel must decide whether to accept it and delay, or to wait as too late. For viewers, it's cinematic. Victory on paper, but undermined by timing and procedure. The moment dramatizes how courts prioritize orderly presentation of evidence. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
And just so it's clear, I've got 43 pages of exhibits from the plaintiff here.
Sorry about that, Your Honor, but we felt it was necessary given what her concerns were.
And you just have to wait a second, because the online system must be very busy today when other courts are using it, and so therefore it's frozen.
Your Honor, can I make a statement? I have another statement I'd like.
The court notes 43 pages of plaintiff exhibits, an image of meticulous preparation. That visual drives home a simple point. Thoroughness wins in litigation. The plaintiff's documentary depth contrasts sharply with the defendant's ad hoc approach. For anyone watching, this is a textbook example of how organization and record-keeping create persuasive courtroom narratives and often determine outcomes before motive pleading can. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
Your Honor, maybe this will help. If you look at Exhibit 1, which is actually the loan agreement, on the second page of it, at the very top, I'll let you get there, so it's probably easier once you're there.
Okay, what's the very top say?
Itemization of the amount financed. You'll see that she financed $13,644.13. That's page 2 of the loan agreement. It says amount given to you directly, $7,000. Amount paid
I'm missing something. I'm looking at something different then. Let's see. I'm looking at Exhibit Index Loan Agreement, Exhibit 1. Then here it says Exhibit 1 Loan Agreement. Then the next page says Loan and Security Agreement Disclosure Statement.
Go to the next page after that. Your Honor.
Okay, that's the second page then. Okay,
No problem.
there it is. Itemization of amount financed. Go ahead.
$13,644.13 was financed. Amount given to you directly, $7,000. Amount paid on your account, $6,644.13. So she thinks she paid $8,000. I think she's considering the $2,000 or so she's made since this loan atop the prior loan's payments. I think that may be where her confusion lies, but my client did lay this out right on the loan agreement.
And it shows $6,000, which was what she paid on the other loan. Is that what you're saying?
It's representing that other loan was paid off to the amount of $6,644.13.
Right.
The judge walks through the loan agreement line by line, explaining the finance amount, what was paid on the prior account, and how interest and penalties accrue. This is dry but decisive. Numbers and contract clauses usually decide disputes like these. The commentary take. The law loves specificity. Contract and itemizations are the scaffolding courts use to dismantle competing memories and establish the ledger of truth. This detail matters because it shows how process dictates outcomes. Documentary proof outweighs unsourced assertions.
To be in the disclosure statement.
That's what they're saying.
Okay.
Well, you signed, ma'am, I'm looking at your signature on it.
I have accuracy.
How you gonna say this is inaccurate? And you
because
signed
they
it.
have documents. They have documents to say what they wanted to say.
And you have documents that refute them that you left at home. It's starting to sound like you're swimming in shit's river without a snorkel. Nevertheless, without the evidence that proves your case, the judge really only has one option for her ruling.
I have the
Ma'am,
two
listen, I'm gonna have to go ahead and finish ruling on this. I'm gonna end up having to grant this motion for summary disposition. There's just no basis for what you're saying. I'm looking at the original loan document for this, which seems to take into consideration the payments that you made previously. And then you've already made some payments on this loan agreement as well, which equals the amount that you're saying you paid. And it's all shown here.
No, it's inaccurate. Those
All
are.
right, well, I don't know, but I don't see any genuine issue material fact other than you complaining that it's inaccurate. I don't
No,
see
it's
anything.
not. I
You haven't
wouldn't
showed me
make that
one
up.
thing that's inaccurate, so therefore the motion is going to be granted. If you think there's something wrong, I'm so sorry, but you do have a right to appeal, and you might want to go downstairs and appeal to a higher court within 21 days of today's ruling or whenever this order gets entered. But there's just no issue here that I can see that would require an actual trial here. So I'm going to ask the plaintiff to please prepare the order on both the motion to dismiss being denied.
The judge delivers a blunt rebuke about missing proof and then grants summary disposition. The courtroom climax. This outcome is a predictable result of swapping evidence for rhetoric. It reinforces that civil justice rewards documentation and procedure above protest. The ruling closes a courtroom chapter, but leaves open the right to appeal. Please like the video, subscribe to the channel, and we'll see you in the next video.